Good morning, good afternoon, and good evening to all our attendees. We have our chairs here, Doug Rice and Andrew Sanders. Thank you so much for joining us. We have with us a unique kind of topic here. We are glad to have you joining us for this entry in the series regarding regulatory and governance issues for blockchain technology. We've got with us today from Hall Booth Smith, Richard Sheinis. Richard, welcome to the call.
All right, David, thank you so much. I appreciate you introducing me. Just for everyone's background information a little bit, I practice in the field of data privacy and security. I appreciate HTNG allowing me to be a member of the blockchain work group and for the opportunity to present this webinar. A goal of the webinar is to provide you with a general understanding of how the data privacy and security laws impact the use of blockchain. And while it would be nice to be able to tell you that a certain blockchain or a certain type of blockchain meets the legal privacy and security requirements, or that another blockchain does not, the use of blockchains is not yet mature enough to provide us with such specifics. None of the legislative bodies, whether it be the European Commission or perhaps the supervisory authorities in the individual member states in the EU have commented on blockchain or provided any guidance as to how blockchain can be used and still fit under the privacy and security laws. So what I hope this webinar will offer for you is a framework of issues so that when you consider using a blockchain application, you know the questions to ask, you know the issues to address, or even better yet, you know the questions to ask of the other people within your organization. So we've divided the blockchain into the topics you see in front of you so that first we will address some of the laws, the privacy and security laws around the globe impacting the use of blockchain. We'll then delve into some of the more specific privacy considerations when using blockchain, then onto the security issues about which you might be concerned when you use blockchain, ending up with some of the other, I'll call them miscellaneous, other legal issues, and then finally winding up with any questions you might have, and I will do my best to answer those questions. So as we move on to some of the laws impacting the use of blockchain, as you see on the slide, GDPR, the General Data Protection Regulation in Europe, has become the de facto gold standard for these types of regulations. And what is a little bit curious about GDPR or any other regulations that have come behind is my theory is that the law always lags behind technology. So when we look at GDPR, for instance, GDPR first came out in 2016, April of 2016. Everyone got a 2-year run-up to become compliant. It became effective in 2018. As of tomorrow, we'll be in May 2019. And so we'll be basically 3 years old for GDPR. So when we look back at blockchain and then, of course, the years of development that it took to get to GDPR, blockchain was really not on anyone's radar. Blockchain was used as the basis, the technological basis for Bitcoin and digital currencies, but really getting into the everyday uses of blockchain, whether it be hospitality, fintech, and so forth, really was not on anyone's radar. So what we're left with is a set of laws that does not address blockchain, does not consider blockchain, and then we have to determine, well, can blockchain still be used in a way that meets GDPR or other data privacy and security regulations? Has GDPR and the other laws actually inhibited technological innovation? I think that happens sometimes because when developers are looking at putting together new forms of blockchain or advancing blockchain, One thought is, well, if no one can use it because it doesn't meet any legal requirements, why develop something and spend the time and money that no one can use? So it can be a little bit like trying to fit the proverbial square peg into a round hole by developing blockchain, altering it in a way so that it fits into that GDPR or other privacy regulation round hole, so to speak. So I'm presuming that most of you involved in our industry have a good basic working of GDPR. So one of the things that comes up in GDPR and has been copied quite a bit in the regulations in other countries are the data access requests, the right to erase, the right to know where your data is, the right to control data, right to portability, right to rectification, and some things like that. And those all present their own unique challenges in how can we meet these requirements, meet these data requests, worry about cross-border data transfer requirements when the very basis of blockchain with a distributed ledger can have nodes in all different locations, which includes several different countries. So we're looking at how do we fit blockchain in to make sure that we can still meet these types of requirements. Other countries have very similar laws to GDPR. Some of them have what we'll talk about, what are called data localization laws, and they're generally modeling their laws after GDPR. So some of those countries, obviously, like I have there, include Brazil. Please don't ask me to pronounce the name of the Brazilian General Data Privacy Law there in Portuguese. I don't speak Portuguese. But the Brazilian law, not actually quite in effect yet. It was passed in August of 2018 and goes into effect in February of 2020, so a little less than a year down the road. And as I say there, it's very similar to GDPR, has a lot of the same requirements as far as data access requests. And I'll keep coming back to those data access requests because I think that dealing with those requests under blockchain is one of the most difficult issues that we have to address, one of the most difficult governance issues in making sure that blockchain meets those requirements. Argentina is another country that has passed a new bill to replace their old data protection law. And now Argentina, following Brazil, following GDPR, for the first time has a right to be forgotten. And what jumps to mind, and we'll discuss in a little more particularity, is if a blockchain is immutable and supposedly forever, how do you erase all of that data when someone exercises their right to be forgotten? Some of the other countries that also are passing laws that would be that might impact the use of blockchain. Japan's Act on the Protection of Personal Information, which is actually, that's very old, Stone Age old in terms of the development of blockchain and privacy laws. It's from 2003, but they amended it in 2007 and also added all of these data access rights that give individuals, data subjects, more control over their data. So now under the Japanese amendment, people can request to have their data disclosed to them, to have their data corrected, add to it, delete it. Another aspect of the new Japanese amendment is that there are now conditions for transferring data from Japan to another country. This is familiarly called under GDPR cross-border data transfer regulations, where certain mechanisms have to be in place before data can be transferred from the what I'll call the home country, in this case Japan, to other countries. One interesting note is that the easiest way to transfer data, for example, going back to the GDPR, from the EU to outside the EU is if the data is transferred to a country that the European Commission has issued what's called an adequacy decision, which simply means that the European Commission has said such and such country, I'll use Canada as an example, Canada has a national data protection law. The acronym is PIPEDA. And so the European Commission says PIPEDA is a good law. It protects data. So if you transfer data from the EU to Canada, you don't need to use another mechanism to ensure the safety of that data. The U.S., by the way, does not have an adequacy decision. We're not considered safe, so to speak, under European Commission rulings. But Japan has been in discussions with the European Commission to achieve the status of having an adequacy decision. It's not quite there yet. Brexit presents some additional challenges. We know, of course, that Brexit is still in some ways up in the air. And so the question is, well, if Brexit goes through and the UK is no longer part of the EU, how will that affect that cross-border transfer and under blockchain, the distribution or distributed nodes, the best comfort I can give you is the things that I have read have indicated that there would be at least a grace period of a few years after Brexit, during which time the UK would honor the privacy laws of the EU. So I'm certainly not an expert on Brexit, but that is some comfort, and we would have to see what would happen after that, and are there other challenges that might come into play for the use of blockchain should Brexit occur. Two countries that I think present additional unique considerations for blockchain are Russia and China, and probably more so Russia than China. Russia has what's called a data localization law. What that means is that the personal data of Russian citizens, people in Russia, has to stay in Russia, has to be stored in Russia. Now, there are those who say, and I won't get off into a political discussion, but there are those who say that the whole purpose of that localization law is to allow the Russian government to spy on the data. But like I say, that's for maybe the politicians or pundits to comment on. For our purposes, when we're dealing with a law that says the data has to stay in Russia, but copies of it can leave the country, the question is, what are the copies? When we have distributed nodes, does each node have an original? Does each node have a what is considered a copy with the original staying in Russia? I'm not 100% sure of the answer to that, but I do know that it is an issue which we would want to address before jumping into blockchain and finding out more details about blockchain applications that are being considered, how they do things, and will you fit within the Russian law. Under the Chinese security law, Chinese cybersecurity law, which came into effect in 2017, it provides very broad powers to the government to inspect data. So the question there is, if they're exercising the right, the government that is, to inspect data, how are they going to go about that? And will the distribution of data in the blockchain affect, not infect, maybe that was a Freudian slip, affect the inspection that the Chinese government might do. And the Chinese government, or the Chinese law, I should say, does also have a data localization component to it. However, it is a little bit more limited than the Russian law. The Chinese law, the data localization requirement applies only to critical type infrastructure. I don't think hospitality would be included within that, but you never know. Maybe they would say hospitality and tourism is such an important part of the Chinese economy that it is part of the infrastructure, and therefore the data localization law applies. I'm really not sure that that's a little bit of speculation, but it is just an example of where we don't know really how some of these laws will be interpreted when it comes to addressing whether blockchain meets those laws. So now as we move on to some of the laws that are in the United States, to mention that also will potentially have a little bit of blockchain, being a round peg fitting into a square hole, is the California Consumer Privacy Act, which was passed in 2018, goes into effect in 2020. One quick side note on the CCPA is that it's still changing. What that means is even after it was passed, there's still the ability for the California legislature to amend the law before it goes into effect. Along these lines, something that is of important note is the definition under CCPA of consumer, and they use the term consumer, kind of equivalent to data subject under the GDPR. But initially, the definition of consumer included employees, so that everything in the CCPA would apply to all employees in California. Fortunately, there's been a recommendation which has been adopted by the committee overseeing CCPA that it should not apply to employee personal data. So hopefully we will not have to worry about that aspect. But what the CCPA does say, and which I'm sure it will continue to say even after 2020 comes, is that it's a focus on consumer rights when it comes to their data. So very similar to the data access rights in the GDPR and some of these other laws that we've talked about, Brazil being one. People, the consumers, have the right to know, and the businesses have to inform the consumer when requested, where is the data? I want my data changed. I want my data deleted. I don't want you doing certain things with my data. I don't want you selling my data. I want you calling my data back. Those types of things that a consumer or California resident can request. So very similar to the analysis under GDPR, when we're dealing with these various nodes that are part of the blockchain, how do we accommodate these requests appropriately? Washington, interestingly, when I first wrote this PowerPoint, the legislation, which is very similar to CCPA, was first passed by one of their houses of their legislative body. It has since been determined it will not get further. I think it was not approved by a committee. So just learned in the last several days that that legislation will not become law this year, but it might in the future. So we're not too concerned about that one right now. But I am sure that there will be other states that will follow suit. It's the wave, just like we went from 1 or 2 states with data notification laws in the U.S. to now all states having data notification laws. I think these privacy type laws providing individuals with more control and access over their data will continue to flow in. Some of the more national laws, under the Federal Trade Commission, we have something called the Unfair and Deceptive Trade Practices Act. What's a little bit alarming about that particular act is that it does not have standards like GDPR. It just says follow your own privacy laws, essentially, and protect it. The Unfair and Deceptive Trade Practices Act itself is from the 1920s. So forget about blockchain, forget about internet. It's just something that has been used and adapted. So blockchain might be one more adaptation, but it certainly does not address how blockchain would fit in with what is determined to be a fair or unfair trade practice or a deceptive trade practice. I put HIPAA on this. HIPAA is probably pretty foreign to the folks on this webinar, but HIPAA is the United States law regarding medical information, medical records, and has some very strict requirements regarding when medical information can be disclosed. And it applies generally to medical practices, but businesses, whether it be in hospitality or other industries, depending upon the type of health plan that you might offer or operate for your employees, and I won't get too far off on a tangent, but I'll just say depending upon the type of health plan you have and how you may or may not get medical information of your employees, HIPAA could be subject to your business as a health plan. So there is that concern. So the question is, again, under HIPAA, how do hospitality entities fit blockchain in when HIPAA is very strict with regard to how medical information can be disclosed, when it can be disclosed, to whom it can be disclosed, and how is all that done under blockchain. So let's move on to some of the specific considerations and issues that we want to talk about. Now, we know, of course, blockchain is a distributed network. That's been the subject of other HTNG resources, whether it be the white paper, webinars, and so forth. But I think it is just important to note that the difference that has been referenced in these resources between a public or permissionless blockchain and a private or permissioned blockchain. In our context and in our industry, I think generally we are talking about the use of private or permissioned blockchains that are controlled with only certain people that have permission to be part of the blockchain, as opposed to the public blockchain, the Bitcoin type blockchain where anyone can join. I don't foresee public blockchain really being used in the hospitality context. So with that very little bit of background reminder, let's look at some of these specifics. So GDPR and these other laws have very extensive data access, permission for data access requests. So the question to ask when considering blockchains, or sometimes the answer is a blockchain within the blockchain, if a guest from a hotel makes a request for their data to be deleted or rectified, well, the principle of blockchain is that it's immutable, right? Isn't that what everyone loves about it? It's immutable, so it's less susceptible to being changed or to hackers taking advantage of it. But when we have data in the different nodes and the data is part of a block in the blockchain, the question is, how is the blockchain application or the developers going to handle a request to delete data or a request to rectify the data? So that's a discussion that has to be had with the blockchain application vendor as to how something like this is specifically handled. A related issue is that terms that people might be familiar with under GDPR is data controller, data processor. In most contexts, or at least frequently, the hotel is a data controller. They're receiving data from the guest, and they might use processors, technology applications that then access the data, do something with the data on behalf of the hotel. It's all over the place. Well, one of the things that Article 28 of GDPR requires is that there be a contract between the hotel and that vendor who's the data process, essentially where the processor, the vendor, agrees, yes, we're going to take care of this data, we'll follow all the requirements of GDPR, the data is good. Well, the question in blockchain with the distributed nodes that all have access to the data is, are each of these nodes considered a data processor? If they are, well, then you need this Article 28 contract. We often call it a data processing agreement with each node. Is that really feasible? And is each node going to be able to fairly and truthfully represent, oh yeah, we're compliant with GDPR, we do all these things, we'll take care of the data, no problem. So that's, I think, a serious question that will have to be asked, whether the nodes are data processors. The next issue after the data access request, looking at these cross-border transfers that I referenced earlier. So if each node has let's say, a copy of the data. Well, if they're not in a country where there is one of these adequacy decisions I mentioned earlier, then you need to do something else to make that transfer to this other country, this third country, legal. One mechanism is something called standard contract clauses. It's a contract, if you will, between the controller, say the hotel that is in the EU, and the processor that is outside the EU. Well, do we then need these standard contract clauses or another mechanism with the nodes that are the people that operate the nodes that are in these other countries? I think that's a difficult question to answer, and it might depend upon what access the node has, but it is certainly something that we have to look at and understand. If that's the case, then how do we go about fulfilling the GDPR requirements regarding cross-border transfers and transfer limitations in the blockchain context? When we're dealing with the Russian localization law and their localization law that says the original data has to stay in Russia, although copies can go to other countries, my question is, which is the original data? Does each node have an original? Does one node have an original and the other nodes have copies? Does everyone have a copy? And so that's a question that I think we need to answer in order to determine if the Russian localization law is being complied with. So I know it sounds like I'm giving a lot of questions without too many answers, and some of you might be saying, oh, typical lawyer doesn't want to give an answer. And I'll say sometimes I resemble that remark, but in this case, it's just that this technology has not been addressed by any of these legislative bodies, and it's not addressed by any of these laws. And the triple whammy is the laws, in my opinion, have not been developed with blockchain in mind. So it goes back to, it's up to blockchain to fit within these laws as opposed to the laws accommodating blockchain. So as we look at a few more of these considerations, one of the next considerations is consent, which is frequently used in our industry to process data. We send or ask our guests, do you consent to us sending you marketing communications? That's just one basic example. We all do something like that, it seems, but someone who has given their consent can later withdraw that consent. So if they withdraw the consent, how is that handled? What does the consent go to as far as, can you make sure that all the nodes do not do anything further with that data? And oftentimes when someone withdraws their consent, they also want their data erased. So it brings us back to the issue we discussed before with request to erase. The next one is records of data processing. The GDPR and some of the other laws have a specific requirement. GDPR is Article 30 that says you will keep a record of all data processing that you do. Part of keeping that record, we're specifically required to say, who are the data processors that get the data? Where are they? Are they in the EU or in the country where the data is from? Are they in another country? So the question is, when we are creating a record of data processing that we are required to do, what is the record? When we have these distributed nodes, even within a private blockchain, are they the processors? Is that part of the record? Or even if they're not processors, but the data is also still in these nodes, what can be said about how you record a record of that data, of that processing? And then lastly, for this slide, the sharing of personal data. One of the requirements for information that needs to be provided to the data subjects or individuals is all the information that's commonly in our privacy policies. What the privacy policy does is it recognizes Article 13 in GDPR that says when you collect data, you have to provide all this information to the data subjects. We all put it on our privacy policy, put it on our website, maybe registration cards, other places. That's fine. But one of the elements in the privacy policy is telling people, who do we share your data with? Well, when the data is in blockchain, and again gets back to the distributed nodes, how do we describe it? How do we account for that? How do we let the data subject know, in the interest of being transparent, which is another requirement of GDPR, and another requirement being that we share it with as few people as possible? How do we describe that? How do we tell people about that? And how do we do that in a way that meets not only informing the person, but also minimizing the sharing of data to the extent possible? So that's just another one of the issues that we have. Privacy policies, of course, is not just GDPR, but we have the rules under the FTC that we talked about also require that we have privacy policies. So a few more last privacy issues and considerations to address that we have coming up. Guest tracking is something that in my research I've come across a number of times being a good potential use for blockchain tracking guests, so you know when they leave the airport, when they arrive, check in via their smartphone, access to their room, check out, everything being done that way through the smartphone, and it goes on a blockchain. So how is that going to be addressed and done in a private manner to meet the regulations? Leaving blockchain, a little bit like leaving Las Vegas. At the end of an agreement, let's say, we have a vendor, we've used blockchain, for whatever reason we want to go to another vendor. Do we use the same blockchain? Do we try and in some way migrate the data? Today, when we're not using blockchain frequently, if we're using a vendor to perform a service, we're switching to another vendor, we will frequently just migrate the data from vendor 1 to vendor 2 and make sure vendor 1 does not have any copies of the data left. Well, now, how do we do that? Does the data go from blockchain 1 to blockchain 2? And if that happens, how do we delete the data from blockchain number 1? Or does the new vendor take over blockchain number 1 so that the data stays where it is? It's just a different vendor that is over the data. I could see there being intellectual property issues with that. What vendor wants their blockchain to be taken over by another vendor? I don't see how that would really be feasible. So we're back to, how do you migrate the data from one blockchain to another, at the same time making sure that the data is deleted or destroyed from the first blockchain. So some ways of addressing some of these issues and privacy that I've learned about really through discussions with others in this field is data being encrypted before it's put on the blockchain in the first place to be encrypted on the blockchain. And this way, the nodes, or people, if you will, that operate the nodes, do not see the data. It's encrypted. And in some cases, that might make the data anonymous. In some cases, it might make it pseudonymous, and different rules might apply. Another mechanism that I've learned about is that the nodes, while they might have access to the block, they don't have access to the content of the block, that they can do the algorithms and the hashing and encryption in order to effectuate the blockchain without seeing the actual content, the data in the block. So those are some things to look at. So I do think it's important to have a very thorough understanding of someone on your team that understands these blockchain mechanisms. Moving on to some of the security issues and considerations. As you can see, we only have one slide for this. We had a few slides for the privacy considerations because I think there are more of them. It goes back to blockchain being developed, in my opinion, really to address security issues, making it immutable, starting with Bitcoin. I don't think there was a lot of consideration to the privacy aspect, and certainly not to the privacy regulations that are in effect today. So just a few comments on this is that when we're looking at how are maintenance and security updates done, who is responsible for that, and what does that change as far as the contents of the blockchain? Who has the ability to do that? Data breaches, while the idea of blockchain certainly, or one of the benefits of it, is to minimize data breaches. Hackers can still easy for you, can still steal the private keys that are used to access data. So it comes back sometimes to the problems with the end users that are often the weakest point in data security, which is the theft of those private keys. I've even read what's called, and now I cannot remember the name, the majority principle, where if a hacker does get control of 51% of the nodes, then they can control the blockchain. So just to note that while for security issues I don't think are as prevalent as the privacy issues, blockchain certainly is not 100% infallible, not 100% secure. And we all know anytime a new technology is developed for security, then the bad guys are just developing a new technology to overcome the security that has been developed by the good guys. An example might be, very frequently now, and kind of industry standard, two-factor authentication to sign on, but now there are tricks that the hackers use to bypass two-factor authentication. And we don't know also with regard to these security measures, GDPR and other laws require technical and organizational security measures in order to protect the data, keep it secure. Well, where does blockchain fit in with that? Does blockchain meet those requirements and those security measures, which are fairly general because they're going to be different for different industries, different businesses, different types of data, different data subjects, and so forth. So that's another issue, is does the security of blockchain meet the security requirements of GDPR and other laws? And then quickly, because I know we're running up on 45 minutes here, I want to respect your time. Some of the other legal issues that we confront, smart contracts and unenforceability go somewhat together. Smart contracts basically being some type of a rule that is part of the blockchain. When A and B occur, then C automatically occurs according to the agreement or the smart contract of the blockchain. And so the question is, how are these types of things enforced, or are they unenforceable? If a blockchain, let's say someone has a complaint that the smart contract was not carried out as it's supposed to, how does that get enforced? What is the evidence, and how is that dispute addressed based upon what the blockchain does? The government supervisory authorities have the right to audit security measures, audit whether GDPR is being complied with. So how do they do that? What are the records of the blockchain? If a guest exercises the right to delete, how do you show compliance with that in the blockchain? How do you show that a prior blockchain deleted the data when it was moved to a new blockchain under a new vendor? So those are some of the issues to address with or in the context of supervisory authorities or equivalent governmental agencies and the audits that they might be. And lastly, with regard to legal representation, this, I promise, this is not a plug for myself, but what you want to do, I think, is you certainly want to have either on your team or someone consulting with you that knows the technology of blockchain. But on the legal side, it's beneficial to have representation that understands both the technology as well as the legal aspects and what is required. I know we focused on GDPR, but again, I'll go back to that being the gold standard, but understands the requirements of these laws and can apply the laws to the blockchain technology and help you determine when you're considering a particular blockchain application, it looks good, it would help us, it would benefit the service we provide to our guests, but let's also look at it as far as does it apply or does it meet the requirements of whatever the applicable laws are that govern that particular data. And with that, I know we're at 45 minutes, and again, I want to respect your time. I'm not sure if there are any questions that have come through that I should address at this point. David, do we have anything?
We have a number of questions. Richard, first off, thank you so much. That was an interesting and informative rundown of some of the issues that first thing that come to mind when someone says the word blockchain, but we certainly do appreciate your expertise on the topic. We do have a few minutes for questions. Please do direct those to me at David Colia in the chat window. I may need to ask for clarification back, so and please do let me know if you'd like to remain anonymous when I read out those questions. So we'll let a few moments of those populate in. One of the first questions I have for you, though, how can blockchain developers be held responsible if their app or blockchains don't comply with every legal requirement?
Yes, the important thing there, David, is acting before or acting earlier rather than later. It's somewhat similar to any technology vendor that a hospitality enterprise might consider using, which is that you have to build in the appropriate protections in the initial documents, the master agreement, service agreement. Perhaps you might need a what I refer to as an Article 28 data processing agreement, so that you're trying to address the potential problems that might come up. That's part of the job really of any contract, is envision what issues might occur and address them in the contract so that should the problem occur, it is addressed pursuant to the contract. Both parties' responsibilities are clear rather than a problem coming up and everyone looking at each other and saying, what do we do now? So there are different considerations as far as what might go in the contract, but generally the consideration is the same, is address it up front rather than waiting till later to give yourself some leverage should there be a problem.
Great, thank you, Richard. Another question we have is, how should someone go about finding appropriate legal representation for matters involving blockchain? So again, not to be a plug, but how would somebody go about identifying somebody right for their team? You kind of touched on this a little bit earlier, but I'd like to have your input.
Sure. The place to start is everyone already has attorneys that they work with, certainly. And that's the best place to start. And what is your attorney's experience, and what are they doing both in blockchain and technology? So if you have an attorney that already reviews or prepares or revises technology contracts with vendors, I think that would be a good place to start. Because hopefully that person also has a good understanding of both the laws and the technology, but you want to marry the two. You want to have people who understand the legal aspect, but also understand the technology aspect, understanding also that most likely persons on the hospitality entities team hopefully have even a higher level of expertise regarding the technology of the specific blockchain under consideration.
We do have another question here. We've got time for 2 more, so I'm just going to let them roll in. This next question is, should there be concern for personal data of minors when it comes to using blockchain for hospitality?
When dealing with information from minors, everyone should be aware that the personal data of minors can come under the category of what is commonly called sensitive data. The technical term under GDPR is special categories of data. And the age of when someone is considered a minor or a child, that is one that can differ quite a bit from country to country. Even within the EU, GDPR is pretty much locked in for all the member states in most areas. But one area where each country is allowed to determine the age of majority, is able to determine its own regulation is the issue of age of majority. So in one country it might be 14, another one it might be 16. In the US, there's a law called COPPA, Children's Online Privacy Protection Act. Most likely in our industry, people are not collecting personal data from people or from children under the age of 13, which are the people to whom COPPA applies, are certainly not knowingly doing so. So it's a matter of knowing how that applies. And then it's just like any category of sensitive or special category of data is sometimes the requirements for the level of security measures that you have in place can be a little bit higher simply because of the additional sensitive nature of the data of children, very similar to other categories or other special categories of data, such as medical information, political affiliation, things of that nature. You have to take a little bit better care of them. So you'd want to look at that, and does blockchain meet those, I'll call them heightened requirements of handling special categories of data.
Thank you, Richard. Just give us one last second. I just want to see if there's any last minute questions. That seems to be all of them. Everybody, thank you so much for joining us on our webinar today. I want a special thank you for Richard for taking time and giving us expertise rundown that he's prepared for us. So thank you, everybody. Don't forget, you can register for more webinars at htng.org/webinars. It is plural, webinars. On that page, you'll also be able to find past webinars also listed there too. You're welcome to review this recording and any other episodes of this series. You probably know a few people who weren't able to make it on today's live webinar recording, but you are encouraged to share this link directly with your colleagues. And if you have any other questions or feedback, you can direct those to workgroups@htng.org. Again, workgroups, plural, @htng.org. Thank you, everybody.